Good afternoon. This is Hap May with a Legal Play.
And I am Chelsea El-Azzi, Hap's associate. One of the things that we have done, and I'm currently working on a few of these for various clients, is what we call partition agreements.
Right.
And we have done a podcast before on partition agreements, and some of them I think that podcast and blog actually talked about prenups and postnups and just partition agreements generally.
Right.
And
It basically deals with married couples or about to be married couples that are taking assets which would otherwise be community property and dividing them up so they become separate property, which has some legal and financial consequences.
So I want to focus on partition agreements that are done after a couple has married, because I've done a couple of those recently, where there's couples that for whatever reason, they want to go ahead and just say, Texas is a community property state. And even though we were married and we live here in Texas, we don't want default community property laws to have any say on how we divide up our property and have ownership interest in it.
Right. What mine is mine and what yours is yours.
Okay. Why might somebody want to enter into a partition agreement or a postnup, as they can sometimes be called?
And actually, postnup kind of divides everything up, so there is no community property. Partition agreements may take certain pieces of property and make them separate.
Okay.
So in a partition agreement, you may have yours, mine, and ours.
Okay.
Generally speaking, the postnup, we try to eliminate the ours.
Got it.
So
I
it's
see.
just yours and mine.
I see. Okay. So why might someone want to enter into a partition agreement?
There are a number of reasons. One is, a lot of times, people with a second marriage who have children from a first marriage are concerned about the consequences upon death, or if not death, if during an incapacitation of one of the married partners, such that they want some of that money to go to their children, which may or may not occur if it's community property. So that's one reason. Also, although it doesn't work real well to try to protect the non-debtor spouse from the creditors of a debtor spouse if it's done after the debt has been occurred.
Okay, hold on, because I think you skipped the whole step where there is suddenly debt and somebody owes somebody money.
And that's true. Generally, well, I guess one is for estate planning purposes. People like to do partition agreements.
Okay.
Also, for creditor protection purposes.
Okay.
They like to do partition agreements so that the debts of a debtor spouse or the assets of a non-debtor spouse are not subject to claims from the creditors of a debtor spouse. Now, this works fairly well when you partition them if at the time you partition them, there is no real debt problem.
Right.
You're just kind of doing this prospectively.
Yeah.
And then later on, if there develops some problem, the transaction was done before the debt was around, and it's hard for a creditor to try to set that partition aside. Doesn't work as well if I already have a judgment against me and I partition everything, and they go after my wife's now partitioned interest in assets we had as community. It doesn't work as well if you've done it, after the debt has incurred.
You're saying it doesn't work as well, so it can work.
It can work. Oh, it can work. There's no doubt about it can work. It's subject to some attack for fraudulent conveyance in the process if the non-debtor spouse is not left with enough assets, or the deal is just so kind of absurd that no one would have entered into it, but for they're wanting to prevent a creditor from collecting.
Okay.
In the process. So the earlier you do it, the better. The less debts you have at the time you do it, the better in the process. And that's what why we do partition agreements for estate planning purposes, for
creditor
protection. And in connection with a divorce or perhaps a reconciliation where the couple wants to reconcile, but they want to have their kind of own boundaries as to what properties they have in the process. So those are probably the three areas that I can think of off the top of my head where partition agreements kind of come into play.
Okay, so let's say somebody has entered into a partition agreement, they've signed, executed, notarized everything. Then they've been married and they have been married filing jointly.
For their federal income tax
On their
returns are
federal
filed jointly.
Okay,
Right.
so does entering a partition agreement affect how you might advise them to then file their taxes?
I suppose the answer to that is yes, although there's not a uniform answer to it. Generally speaking, couples that have nothing but community property and community income would file jointly. If they file the married filing separately, you get this oddity that half of husband's income is wife's income and half of and vice versa. So that even if you had one spouse that made $1 million and another one that made $10,000, and they wanted to file separately, absent a partition agreement, then the spouse making the least would take $5,000 of that spouse's income and $500,000 worth of the other spouse's income and file a tax return that way. So that's one of the reasons you may want to do a partition agreement, is to avoid that consequence if you're going to file separate returns.
Well, if flip-flop the order, the partition agreement's been signed, then how do you file?
And typically, okay, we have a married couple. They have this diverse income, $1 million, $10,000, just as an example. And they're basically say that this is everybody gets their own income, and it's their property and their income, and they will report it. Now they can still file a joint return and show $1 million, $10,000 worth of income and pay taxes on it. That may actually wind up being a little less in taxes than if they each split up separately, where the husband or wife, whoever the higher earning spouse is, has the $1 million on their married filing separately, 1040, and the $10,000 that the lesser earning spouse has on hers. I mean, that could be done. It doesn't have to be done.
In what case would you recommend they continue filing jointly after signing a partition agreement?
If there's not a lot of reasons to do it otherwise, you generally speaking will wind up with a lower total tax liability if the couple filed married filing jointly.
Okay, so then the question that follows is, what would be the reasons that you would then recommend someone who has entered a partition agreement to change their filing status and do married filing separately?
Okay, there are a couple of situations where that's true. If the wife, actually, let me not do that. I want to make them. I don't want to say the wife makes less or the husband makes less. Let's say the lesser earning spouse, has creditors chasing.
The lesser earning spouse
yes,
has creditors chasing them.
Yeah, so you want to prevent the lesser earning spouse's creditors from trying to get to the earnings of the larger earning spouse.
And filing jointly
would at least give the creditors of the lesser earning spouse access to information about the other spouse.
If they have a judgment.
If they have a judgment or make a disclosure or file bankruptcy,
you mean the debtor spouse. If the debtor spouse files bankruptcy or has a judgment against them from that creditor, or is legally obligated to file some kind of disclosure in some way,
or in the courses of negotiating a settlement agreement, has to give a financial affidavit saying, this is what I have, this is what I don't have, this is a copy of my tax return. Generally speaking, if I had that much, I were a collection lawyer that was going to say, okay, I'll take 10 cents on the dollar to settle with you, and I knew your husband or wife made $1 million, I might be a little more aggressive.
Okay, so if you check yes to all those boxes, I'm a debtor spouse, either I have a judgment against me, I filed bankruptcy, or I am obligated into some disclosures, you'd say it may be a good idea to file separately. Correct. Just so that Because that is one of the things that I know creditors ask for is, okay, well, let's see your tax return. And
Right.
if you file jointly, then the creditors then have the opportunity to see what your spouse earns.
Correct.
And in that case, what would happen in that case if the judgment is against the one spouse, you've entered into the partition agreement.
Right, and assuming that that's valid, and they don't have the creditor doesn't have a chance to try to do something to unwind that, then
what does it mean if they now know
the-
how much the other person earns?
the creditor may be more aggressive if they realize that the other spouse has, money.
What does that mean? What actions might they take that would
I
be
am
more
going to
aggressive?
make your spouse's life miserable. I'm going to take his or her deposition every year. I am going to demand that they respond to requests for production, and I'm going to garnish. If she has $5 in the bank account, I'm going to garnish it. Not because
Even if
not
the judgment isn't against the other spouse.
not well. That's I am going to put pressure on your spouse to come up with some money from somewhere, and I know she's got access to it because you make $1 million.
Like there are ways to fight that, but you would all. I don't think
Well,
that you want to
I mean,
go down that road with this podcast.
If in fact the debtor spouse, owes money, there's not a lot. I mean, the way to fight it is you file bankruptcy, and then you can explain to the bankruptcy trustee, to take a look at whether or not, with the enhanced bankruptcy powers in Chapter 5 of the Bankruptcy Code, whether the trustee can go after the husband or not. At some point in time, and not on all cases, but at some point in time, knowing that a creditor has a rich dad, a rich spouse, a lot of money in retirement accounts that you can't, garnish, but you can still, try to collect from them until they come up with some money.
Okay. Man, I'm gonna hold my tangent comment until I've circled back and covered this other topic. So that's if it's a non-IRS creditor.
Correct.
We also mentioned, because we did talk about this briefly earlier, that it's also a good idea to file separately if your creditor is the IRS.
If one spouse and not both of them owe the IRS.
Because then if you file jointly and you get a joint return,
they can go after
they can go over the whole thing.
The whole refund. They garnish the whole refund. So
that innocent spouse, the non-debtor spouse, loses out on their refund. Like,
right.
What the heck? That was my money. I earned half of that, at least half, maybe more than half. Okay.
Right. And so by isolating them so that they each are their own separate taxpayers with their own income, their own withholdings, and their own rights to refunds or their own obligation to pay their separate debt, you can keep them from being the IRS from going after the non-tax debt spouse. And I mean, I've had people that say they have decided not to get married because one spouse has a huge debt, and I've told them that's not necessarily should be a barrier.
Mm-hmm.
There may be other reasons not to get married, but I mean, if they otherwise would want to get married, and they're
which you could sign a partition agreement.
You can sign either a prenup or a partition agreement,
and then do the joint filing, or the separate filing.
Right.
Okay.
And if your grandmother would be horrified at the fact you are not getting married, in the living in sin, and that it has an impact on you. I mean, we can find a way to do that. We find a way that you can marry somebody and not marry their creditors.
So I want to just kind of circle back around to have you had any clients in the past, or at least known about this happening, where there is a debtor spouse who has a wealthy spouse and has entered the partition agreement,
All the
but
time.
but where they're actually, the creditors manage to get through to the other spouse?
Oh, yes. The other spouse, the other father, the retirement fund of the
I thought
debtors is
retirement,
exempt.
I thought retirement funds were exempt.
Retirement funds are exempt. So I can just, be very aggressive about
And get to the spouses, the innocent, non-creditor
well, I
spouses.
mean, that's a voluntary action. But even if I have a judgment against you and all you have are exempt assets, am I supposed to say, well, okay, I can't get anything from her? Or should I continue to be aggressive in my collections until you say, how much does it take to make you go away?
Man, your spouse had better love you in that case, because
Well,
I feel like a lot of relationships, you're the non-debtor spouse who's got some assets might just say, you know what, can we just maybe divorce on paper?
I mean,
I'm sure that happens.
and that happens. And does that work? I mean,
Does it work?
I've had cases where I can show you it didn't.
Because if you're still living together and doing everything.
Yeah, I mean, one in particular, I was an expert witness on that. We were able to establish the fact that there were a series of fraudulent conveyances associated with a divorce. A divorce can be a fraudulent conveyance.
Dang it!
And I mean, and frankly,
because what if I'm enjoying my lifestyle? What if I don't want to pay your debts, but I want to keep taking first class tickets and I want to go with you because you're my companion? Like, I want to enjoy your company. But the creditors, your creditors are going to say, nah, if you're flying first class, like, we're just going to make her life difficult.
That's creditors have a certain license to make people's lives difficult. It's limited. I mean, you can file bankruptcy and get rid of it. There's only so much.
Some of it.
Some of it, but a lot of these creditors that are most aggressive are the ones that realize that the only way they can get money from you is to make it uncomfortable for you.
Okay. Yeah, see, we go off on all of these tangents. when my question was, if you've entered into a partition agreement, should you continue filing married jointly or go ahead and start filing married separately?
And unless there is a reason, and many reasons we discussed here, you can keep filing jointly, because generally speaking, that will give you the best tax result. However, if there's some other reason, as we've discussed, not to, then you certainly would be in a position, once you have done a partition agreement, to do that. Okay. To file married filing separately. Okay.
All right. Well, if you've got other questions that weren't answered in this podcast, you know who to call, because apparently Hap has seen it all, or at least a lot of it. And I think that's it for today.
All right. This is Hap May with Legal Play.
Thanks, Hap.